If you are making marketing outreach, get that heightened prior express written consent. It is a laundry list of things that you have to have, but if you obtain it, that is good as gold.
Welcome everyone. Today, this is one of the many content pieces that ActiveProspect is putting together in the weeks and months ahead as we help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules and revocation rules update in the TCPA, which is Telephone Consumer Protection Act. We believe the content we're putting together here today is going to help you decode these changes with more confidence and a focus on compliance. Today's topic: mastering TCPA compliance in your SMS marketing program. Text with confidence, text with compliance. So I am Benjamin Farr, the Director of Privacy, Security, and Compliance at ActiveProspect. For the last 20 years, I have worked for companies in performance marketing, market research space, including WPP, Kantar, Dentsu, with much focus on privacy and data regulation compliance during that time. Also worked at Ernst & Young in New York as an IT control auditor in financial services, and at Ochsner Clinic Hospital in New Orleans, of course, focused on healthcare and insurance. All of my roles were in functions and departments focused on legal, compliance, IT audit, data security, and one clear development has followed me through my career. In each one of these industries and jobs, a significant data regulation or law was passed during that time, and I was on the team that helped in reviewing and translating these new rules, seeking clarity, and establishing a compliance program around the new rules. So things such as HIPAA, SOX, GDPR, state and country data protection laws, and industry-specific ones as well. And now for a brief introduction and background, I would like to pass the mic to my co-host today, Margaret Wise, Chief Revenue Officer at ActiveProspect.
Thank you, Ben. I have a background of 20 plus years working in sales and marketing technology, and going back from sales through to implementation and consulting on the product side, starting when CRM software was new in market. And then as marketing technology has advanced and evolved, and spent some time with a national digital services marketing agency, and really focused on the lead generation path on the digital side, diving deep into first party and third party lead acquisition and how companies optimize for that. And then joined ActiveProspect a little over a year ago, and have enjoyed getting to really understand this part of the market, and in particular, a lot of these very specific compliance regulations that we're going to be talking about today.
Excellent. And now Alexandra Krasovec from Manatt, Phelps Phillips.
Well, good morning or afternoon, depending on where you are. I'm Alex Krasovec. I am a partner at Manatt, Phelps Phillips. We are a national firm, and we do, among many other things, have a consumer protection, advertising, and competition practice, which includes, of course, Telephone Consumer Protection Act. I have been doing TCPA compliance counseling, litigation defense, and regulatory enforcement matters for just about a decade, almost exclusively. It is a huge part of my practice, and I've really seen the whole, running in what activity has been coming from the FCC as it ebbs and flows. And definitely right now it is hot and heavy, which is, I know, what we're here to talk about today. So very excited. Thank you, ActiveProspect, for having me, and looking forward to our conversation.
Awesome. Thanks so much. So I know that we have a variety of people in our audience today, and I want to really address some of the questions and use cases that I think will represent many of them as people that are purchasing leads for their business, focus on lead acquisition. And so starting out, one of the first things I want to talk about, we're here to talk about texting today. And I've heard definitely some horror stories related to lawsuits for TCPA violations. I know they're subject to private right of action. They can be fined beginning at $500 per call violation. And so one of the first questions that, if I'm a brand and I'm thinking about texting as part of my program, is like, how does the FCC think about text as it relates to TCPA and the stories that I've heard related to TCPA and calling?
Well, texts are definitely covered under the TCPA. The FCC has made very clear, particularly with regard to automated calling activity, that those kinds of text messages would be covered and are required to comply with the consent obligations. There have recently been some developments with the FCC, including the order that issued in December and was, finalized in January. And that one also confirms that text messages are covered under the DNC rules. So all in all, SMS not exempt, and very important to be paying attention because, as you mentioned, Margaret, the damages exposure as a result of failing to comply is very significant.
Yep. Perfect. Thank you for helping clarify that. I always think about when we're approaching this and, companies thinking about, why should I care about this? Is it really risky or not risky? Or those lawsuits that you hear about, are they one-off or they don't relate to me? So I know that's something that we really want to talk about today is where do they relate, where they don't relate, and who should be worried about them and who shouldn't necessarily be worried about them. And I think that later part is a very small segment of, of folks that don't need to worry about it. So as I think about that and I think about, okay, I'm texting, I have customers, I have prospects, I have product communications I want to share out to customers, but maybe I also want to repurpose that content and push it out to prospects as maybe more promotional. How should I be thinking about all of this in terms of what's informational versus what's marketing, what requires consent, what doesn't?
So first off, the TCPA takes a very broad view of what constitutes marketing. Basically, the way to think about it is anything that is not anything that's not purely informational is really considered potentially marketing. And I mean that in the narrowest sense. So, informational communications with your customers about existing accounts that they have with you, right? Alerts about maybe security issues with their account, right? Those are informational. Marketing is going to be kind of everything else because, what we're looking for is to some extent, what meets the definition under the regulations, which is, are you going to be promoting a good or service? Are you trying to encourage the purchase or sale of that good or service? But courts have construed this broadly when they apply it, right? So even things that you're putting into your text messages, like links to a web page, courts will look through the link. They'll look to the web page. They'll see what content is on that page. Courts ask questions like, are you trying to drive traffic to your website? Are you trying to engage folks and get them to enroll in your new app? Download your app, for example. Other issues that we see are kind of around the survey space, right? If you're trying to get somebody to come give you a Google review, that is a marketing issue, right? Because the whole purpose of making that outreach is to get some sort of public facing benefit, basically driving engagement or ROI, right? You're trying to get folks to come to you. So anything that looks even remotely like that needs to be treated as marketing. And the reason why it matters is the consent standards differ as between informational and marketing calls. And I know a lot of folks probably know a lot of this, but for those folks that consider this to be new or just a little refresher, informational calls and text messages, they only require prior express consent if they're made with an automated system. So that would be someone gives you their phone number in the course of a transaction. But if you are doing a marketing communication using an automated system, then you need prior express written consent, which is a very specific type of consent. And it has, specific requirements. And we can talk more about those in detail.
Okay. So I think one thing I hear you saying is don't think you can gloss over a marketing message and because it's text and make it kind of look informational on the top, but underneath you're really fishing for more business.
That's definitely true. I mean, look, this is what courts consider. They consider the copy in the message, they consider any linked material, and they also consider the purpose of the outreach. So if it's kind of like subterfuge, what you're doing, the court may find that. Now, I think there are fair cases where there is really a question. Maybe this is transactional, maybe this is marketing. A lot of those close cases, the gray area we see arise in things like the renewal context. There's, cases going either way on that, sometimes in the loyalty program context. So it really is going to depend a lot on the situation and your comfort with the level of risk. Obviously, the most conservative approach is to assume that what you're doing there is marketing and then get that prior express written consent. That's going to be a business call.
And so since this is not official legal advice, if anybody's concerned about the gray areas, they should reach out to a legal expert like yourself to clarify and be sure.
Definitely. This is purely informational and definitely intended for educational purposes.
Perfect.
Alexandra, question. So from me, is it appropriate for a company to use a different phone number, or I would refer to it as channels for outreach, if one is purely informational and one is marketing? Is that a strategy, or does it necessarily not matter when the courts view this thing, or even from the regulation?
Ben, that's a great question. So I'm going to answer it in two parts. The first is as things currently stand today, and then the second is going to be a note about something for the future. And I know that we're going to get into that conversation. So for today, practically speaking, there are good reasons why companies decide that they want to have separate channels for that kind of outreach. And a lot of it really comes down to the scope of consent they're collecting and the context in which they collect that consent, and then managing their SMS programs so that they can keep it streamlined as between the two programs. Let's assume it's two. It could be more, right? But if it's informational channel and marketing channel, well, for informational, then you're going to be sending certain types of communications, and you can manage your opt-outs within that informational channel and not really have to worry about what's happening on your marketing side. The marketing channel, same, right? And a lot of folks might handle their informational communications, but send their external, their prior express written consent required type marketing programs to a vendor, right? So there are good practical reasons for keeping them in a divided fashion. There's also the phone number question, right? Are you using the same phone number for both programs? And there's a whole lot of considerations that go into that. The second part is for future. The FCC recently issued a proposed ruling basically on the revocation issue. And I do think that what the FCC is planning to do here is going to impact how people operate in that regard.
Yeah, we're definitely going to have to stay tuned to that. Going to be some coming news on that in the coming days and weeks ahead. I think it's good time for a poll question so we can understand the audience a little bit better as to who has these types of text message programs. So take a look at our poll section there. And our question is, do you have a text messaging program? And our responses are yes. Options are no, never, or I'm thinking about adding a text message program. So provide your responses and we'll check back at the numbers in a few minutes. So Alexandra, let's talk about a couple scenarios or ways to source consent for text messaging programs. I mean, what's really required in that range?
Well, sourcing consent is actually a very interesting business question, right? So you're going to plan kind of where it is that you want to get that engagement. And there are lots of different entry points, and they run the gamut from, an existing flow that you have, like a purchase or transaction flow or an account creation flow, all the way to a standalone SMS program where you're doing either a call to action or you have some sort of creative where you have a QR code or some other way to access a web form where someone can sign up. Sometimes those kinds of SMS programs are buddied with a essentially a promotion, right? Like 10% off your next purchase when you sign up for our SMS program. And there are lots of ways to approach it. The way in which you approach it will change what is required, especially when it comes to the clear and conspicuous aspect of your outreach. So it's just, we like to talk to our clients anyways about what their end goals are, what they have in mind for how they're going to drive that sort of sign up flow. And then we work with them to get the disclosures in place that they need.
Okay, excellent. So I would think the attendees out there, some of them could be brands, and they're looking to start a program, or they're looking to improve their current program. And you mentioned some could be outsourcing it to a vendor, right? So a third party saying, well, I don't want to administer it. I do it to a third party. And then we've got counterparts that are their brands looking to purchase leads in this space. And then another category of obviously our lead generation service providers. So yeah, provide a little bit of explanation about sourcing leads in those different contexts.
Yeah, so I think what we should do is first level set. When you're talking about a marketing SMS program, we need to be collecting prior express written consent. That's what the TCPA says, that's what the regs say, that's what the FCC says. And that means you need to be identifying the seller to whom consent's being provided. You need to identify or confirm the phone number that the consent is being provided for. You need to obtain a consumer's affirmative agreement to receive advertising or telemarketing communications, calls or texts, by an automated system. And you also need to advise them of the fact that they're not required to agree to give that consent as a condition to make a purchase or of goods or services. And those certain disclosures need to be clear and conspicuous. And then you also need to obtain a signature in writing from the consumer. And that can be, electronic. It could be actual, wet ink signature. There are lots of ways to do that. So when you're collecting that prior express written consent as a brand, a lot of that is housed under one roof, right? You know where you're going to be publishing that disclosure. You have control over content of the disclosure. You hopefully, and I encourage you strongly to, work with your TCPA counsel and making sure that everything is content-wise and clear and conspicuously disclosed. And then you are going to be collecting consent. So obviously you have to be focusing on what data points are we collecting, what records are we keeping of consent, and all of that. When you outsource to a vendor, a lot of that is very similar. Your vendor should be working with you to make sure that someone is responsible for that consent aspect and the record keeping. And all of your disclosures and everything are going to be very similar. Just, depending upon where they're published, you may have to make tweaks. And when I'm talking about these items, I'm talking about current state. What we will have changing soon with the FCC order from I'm going to call it from January for shorthand. We are going to have a heightened prior express written consent requirement, even more so. And there are changes there and consent requirements for maintaining records, right? And so right now, to level set, those things are not in place, but they will be soon. And we'll talk about what you need to do for that. So the third category that you mentioned, Ben, is the lead gen context. Before I move, I do want to say you're going to have with a vendor, you're going to have a contract. Your contract, your terms are going to have provisions in it. And you're going to want to make sure you're addressing who's responsible for collecting consent, who's responsible for maintaining records, and whether and how those records are shared with you. And you're also going to be wanting to address what happens if you end up with a claim. So those are all factors, and they exist with the vendor. You don't have that in-house. When you move to a lead, go ahead, Margaret.
Yeah, I was just kind of curious about that because I was going to ask specifically about those contractual agreements. Are you seeing a lot of those starting to change already in preparation for enforcement of the ruling? Or are you expecting a wave of that at the end of the year for those updates? Or are you seeing a lot of that conversation activity already kicking in?
It is definitely an area that we are recommending our clients consider as an action item for the lead up. It is going to be necessary, especially when it comes to the record keeping. Now, if you're an existing client of Manatt, you probably, and you work with us on your vendor agreements, you probably have a lot of the provisions you're going to need. There may be tweaks and things that we want to do with regard to the lead gen space that change here. But certainly if this is like a first pass for you and you haven't done this before, have a TCPA counsel look at your agreements that govern this kind of activity, SMS marketing or any sort of telecommunications activity, because there are specific items you really should be including. And when the FCC order comes into effect, those will become even more important.
Got it. Thanks.
Let's see if we can circle back to our poll if we have the results from the audience here. Okay. Yeah, I don't see those results, but we'll see if that can be displayed in a second.
So I'm seeing 79% yes right now, Ben, okay. And 8% no, and 13% thinking about it. And so it looks like a lot of you already are engaging in SMS marketing. That is really not so much of a surprise given the last few years. I think COVID was a major turning point when folks looked at their email open rate and realized they needed to increase their ROI on their outreach. And texting is a nice, easy way to get to folks, and have your customers see you because they're not checking their email anymore. The issue with that, of course, is that SMS marketing is a higher risk area. The TCPA, as Margaret mentioned, has very serious damages provisions. The FCC has been very busy lately, and I know they're busy enacting rules and regulations, but they're also engaging in enforcement. And footnote, the FTC would like a piece of the action too. So even though they're really primarily focusing on pre-recorded calls, they have not been quiet about text messages. So I wouldn't be surprised to see activity there as well. All that to say, if you are engaging in this activity, you should pulse check your marketing, your disclosures for prior express written consent. Pulse check your vendor agreements and the other activities you're engaging in. And then with regard to this recent FCC order that we keep talking about, but haven't yet landed on a substantive discussion of content, I will preview that you are going to have a lead generator issue. Right. And I know Ben mentioned the one-to-one consent at the beginning of the call, and that is one of the issues that you will need to be assessing. A lot of lead gens are trying, at least historically have tried, to obtain the broadest, most applicable consent possible. That is not the world that we're going to be living in on a go-forward basis. So definitely, if you're engaging in SMS, you're not exempt from the FCC order.
Yeah, and from a compliance and privacy role, individuals in that profession, they understand and have always recognized the importance of that notice, that language, that opt-in language. And the theme of all this is it's getting increasingly important. I mean, we're really determined whether there's going to be actions or whether you can be litigated against. So important to focus on that. And I wanted to make sure everyone is aware that ActiveProspect has a great solution to help you capture that consent transaction on web forms. It's called Trusted Form. We have a variation that does Trusted Form certify, verify, and retain. It will capture the consent that was presented at that point in time. This can be in a first-party relationship or in a third-party relationship. And of course, can help in TCPA defense claims as well, and can also help compliance officers and anyone in that role who's responsible for these programs, as you can check shortly after that and decide whether you want to receive that consent or not. So it's a very powerful tool and very useful, and clearly it's becoming increasingly important with the focus on notice and consent and opt-ins, particularly for TCPA.
I glanced over at a few questions in chat, and I saw a few things in there that we'll probably, I know we've touched on in other webinars and a little bit here, but that concept of burden of proof and the record keeping guidelines that companies need to be aware of, and in understanding that burden of proof has shifted to the buyer, the person that is reaching out to the lead, having that burden of proof, and that going for text as well. If I'm a publisher, like, how do I protect myself as a publisher from what maybe the buyer of those leads might be doing? Let's say we've had a relationship for a few years. I've been sending them leads, and then they decide to start texting as part of that. And I wasn't aware of that as a publisher. Does that change things?
So publishers, take notice. You have a decision to make. The decision is whether you're going to become a teammate to your purchasers, or your clients, your customers, or if you're going to pass the baton to them. Because what we are seeing with the FCC order, we have a 1-to-1 consent requirement. So basically the FCC has said you need to get consent for one seller at a time. We can't be doing, multiple sellers all at once unless you're giving the customer the choice of which seller is going to get to communicate with them. Number two, you need logically and topically related consents. So your pages, your web pages are going to have to match what it is that those communications are going to be. And kind of the classic example is, you can't be collecting consent for solar and then selling it to folks who are going to call on home warranty. That's not related logically or topically to why you collected the phone number. And the reason why publishers are going to have to make a decision is because the sellers have, I'm calling them sellers because the TCPA refers to them, but they're the lead buyers, right? That's who's using the leads. They're going to make the calls. They have an obligation, have always, by the way, had an obligation to prove consent. But historically, the consents were a little bit more flexible than they are now. So there was a little more wiggle room, a little bit less at stake when it came to, whether the consent was enforceable for that particular seller. That's not necessarily best practice, but it allowed you to have some movement. And then the record keeping piece, right? Well, before people commonly would say, when the claim came up, hey, I need a copy of whatever it is that, shows that they consented. And what the FCC has done with the order is shifted that responsibility to the seller, the lead buyer. So they need to maintain that record from the time that the consent is obtained, right? So that when they make the call, they have that record. And so those things will need to be addressed in some way. Most common ways I have seen being discussed, but certainly not exclusive. And definitely there is lots of room for innovation here. But most common ways are you have language in your agreements that addresses responsibility for this, and there's timing for when and how those consent records are being passed. And then the other alternative is like the true direct post, not just direct post as we call it, right? But you really you shuffle that lead over to the lead buyer, to the seller, to collect the consent, so that you don't have to play in that space at all. That they are responsible and they're collecting their own consent, and they're putting, they're making sure their disclosures are good for them.
I'm going to ask kind of one more question here on following up on some of these discussions. We're talking a lot about the FCC, but do the state laws differ?
Yes, state laws. Wow. There is so much to say, and there's not even a 2-hour webinar could cover all that there is to say about state. The takeaways on that are state laws do differ from the TCPA in many ways that you might not expect. In some areas like call times, for example, conflicting, and even on some things like consent content. There are a few states that are really out there in what they want to see in the consent disclosures. And then there's states like Florida that don't necessarily make clear whether or not magic language is needed, but we see the plaintiffs bar arguing that it is. So there are factors going on at the state level. And if you're a publisher or you're working as a lead generator with your clients to come up with kind of what consent do they need, that's going to be a decision point for you, right? Are you going to work closely with your lead buyers to determine what scope of consent they need? Are they going to be engaging with you in the disclosure, right, to figure out if it works for them and make sure that they approve it? Or are you going to go for kind of an all-purpose disclosure? And if you go for an all-purpose disclosure, there are all kinds of considerations with that. State law is one of them, right? You don't know where necessarily your lead buyer is going to be calling. So you might need to have coverage for Vermont and other states that ask for wonky things like AI related communications and things like that. You're going to have another issue with the kind of methodology that they're using to make the calls, the telephony, right? You don't know if your lead buyer is going to text, if they're going to call, if they're using an automated system, if they're going to make artificial or pre-recorded voice calls. And so you might be thinking, I'm just going to go and get consent for everything. And maybe that's fine. But I'm just going to flag that the FTC has read a lot into the kind of consent you're collecting when they've been bringing their enforcement actions lately. And so they're basically coming from the place of making a presumption that your lead buyer is making the calls that you are collecting consent for. So if you say they're calling for with artificial voice or pre-recorded voice message, the FTC is taking that as an invitation that you are aiding and abetting the lead buyer in doing that kind of activity. So there are a lot of considerations there. It's a robust conversation, and it's one really that you have to make with your business and with your counsel.
Well, one more big area to open up here and discuss is related to opt-out and revocation of consent. So we've talked a lot about the opt-in piece of it. What should our audience know about the opt-out side of it?
Well, opt-out, or the ability to opt out, which we kind of for shorthand can just call revocation, is something that the FCC read into the TCPA in 2015. It used to be litigated heavily whether or not you could actually revoke, or if you had an agreement, whether or not a consumer could revoke. But the FCC has made very clear consumers can revoke their consent by any reasonable means. And if you get that revocation, you need to honor it. The FCC now has a pending proposed rule that they're going to be putting up, I guess, tomorrow, right, at the open meeting. And it's going to address in more detail exactly what goes into revocation. And it also is going to change the regulations so that the regulations now speak to revocation, which is not something that they did in 2015.
Yeah, we'll be tuned into that, and everyone who's not aware in the audience that meeting is tomorrow. So look for more updates from us around that space. I've obviously it includes some timeframes, which are eye-opening for the period of time in which that revocation needs to be processed. 10 business days. So that will certainly change things, and particularly from a compliance standpoint of fulfilling those, and then the different ways in which they can be received. So stay tuned. There's a lot more to unpack on that. You're going to hear a lot more in the weeks and months ahead from all of us in the industry as we try to grapple with that and compliance from the most practical standpoint. I think there's another poll question that would be good. This is where we usually try to split the room and when we're in smaller segments. But our next poll is about auto dialing. So the question is, who is not using an auto dialer? And you can say, I'm not using an auto dialer, I am, or I'm really not sure. So that's use that as sort of their safe card. They'll go to the other side of the room or go get coffee and donuts at this point. But we'll see how our audience segments here today.
I think that card is not as safe as some people think, because it's a really tricky definition of what counts as far as automated dialer is my understanding. And Ben, you work a lot on the compliance, so maybe you want to expound for a minute on how you define it for us at ActiveProspect. How do you talk to our customers about it?
Yeah, well, it's complicated. Obviously, the rules in there and case laws, which is what our legal colleagues follow closely as those things build on themselves. I've also always looked at it with it's not really precisely defined, so it's hard to build a program around that. And there's often cases that update this continuously, which we stay tuned of and watch those components. But Alexandra, you can probably run us through certainly those components of an auto dialer.
Yeah, well, so I kind of, what I want to say is the FCC, the TCPA has one definition. And then, it after Facebook technically requires a random or sequential number generator. The plaintiff's bar has not been on board with that because their cash cow is the TCPA, and automated calling was a pretty easy thing to plead because at the time anyways, you didn't have to do a whole lot. You could just say like there was a pause and a beep or whatever. And now I think that my call was made with an automated system. And so what we are seeing is there's still a split. It's just a kind of different split than what exists before Facebook. And I mean the Dewey decision. We are definitely in a gray area still. We have, some courts like the Third Circuit that might be coming out with a favorable ruling, like you weren't using an ATDS, but your system has the capacity to be one. And then we have other courts like the Ninth Circuit that basically say, look, if this is an existing list of numbers, they weren't randomly or sequentially generated. So you're, basically in the clear. And so I do think there's more to come on that. The capacity question is the real burr, the sticker burr. And I really think that anyone making outreach really has to think long and hard whether they actually want to take the position that they're not using an ATDS for purposes of planning and compliance. Because I can tell you in the cases that don't get dismissed at the pleadings that, aren't kind of the really nice, clean Ninth Circuit pleadings decisions, you're in on a factual question. And there are going to be questions about what your system can and can't do. And even little things like you think that your system's calling based on logic. But when the logic results in two matches, the system might apply, a randomizer to determine which one of those goes first. And so you could actually have that capacity lurking in your system and you don't know about it. And so, there's two schools of thought. There's the, should I assess my system and determine how good I feel about it? Or should I just assume it is one and proceed accordingly and get all the consent that I need? And we're happy to do the ATDS assessment. I've done lots of those for clients. And there are certain situations where it matters, a lot. If you can't get consent for your outreach. So now that is the turning point for you. But when you're talking about an SMS marketing program, you have access to the folks that you want to be contacting. You have an opportunity to collect the proper consent. And so there's a very good reason to say, look, let's just get what we need so we don't have to deal with it. Because if a claim is filed and you have a consent record that is, trusted form, right? You are going to have something to show the other side as soon as they show it up at your doorstep and say, look, we have consent here. And by the way, our disclosures are good. And so if that happens, you're going to be in a much better boat than the person who ends up having to stick out the case to summary judgment and prove that their system is or isn't an ATDS.
Yeah, absolutely. And let's pull in our poll question now, responses for that, get the results there. And 45% not using an auto dialer, 30%, 34% saying yes, and then 20% not sure. Interesting results. Cross section of sort of all in each bucket here today, which is what I would have thought. So that's great.
Yeah, I mean, if you're in the bucket saying you're not using an auto dialer, the question that you should ask yourself is whether or not anyone has actually given you a legal opinion on that. And if they haven't, consider, whether or not you want to get one. If you are not collecting consent based upon that assumption, then that is probably a very important thing for you to consider. But I think that's what happens with this SMS question. Actually, it's a little interesting because when Ben, Margaret, and we all started talking about doing this, my first thought was like, well, I wonder how the FCC order really applies to SMS, right? Because I think historically we were thinking under Facebook that a lot of SMS programs would kind of be not ATDS, but as the case law has panned out, that's not really true. So, for folks who are wondering that same question, right? How does the FCC order affect my SMS program? Well, it does in many ways because of this potential risk, right? And so that is why the prior express written consent changes, et cetera, are important for you to pay attention to.
Great. Those are awesome insights. Thank you so much.
All right. And framing another simple question. How long does consent last? Right. That's the common, everyone wants to know. What's the simple answer for that?
I get that in almost every conversation.
Yeah. Well, I was seeing a lot of questions in the chat on that. So I'm not going to, make you guys wait any longer. Okay. So consent is technically good until revoked. There is an asterisk on that. You also need to be aware of state laws. There are a few states that have certain consent rules that impose kind of a time frame. And, I'm thinking of Georgia, which has 5 years. There are others that I think at least have been talking about it. So just, yes, you're looking at unlimited until revoked, but there's that. There's also the reassigned number issue. If you're collecting consent, it may not actually be good forever because you don't know what's necessarily happening on the other side of that phone. And if your customer changes their phone number and hands off that phone to somebody else, then you might actually be reaching someone who didn't give you consent. And kind of the longer the time that passes, the more chance of a stale consent there is. So there's good reason to have your own internal sunsetting or protocols for getting your customers to confirm that their phone number is still theirs in certain ways. And that's stuff that we can talk about, offline, of course, but definitely consider that as a factor. Don't just think like, I get the consent once and I'm done.
All right, excellent. Well, now let's see if we can address some of the questions in the question section today. The first one I see, which I think we just alluded to, but see if there's any variation. If I'm a lead provider who gets consent before I buy the lead, how long am I allowed to text the prospect?
So this question is interesting because there's a lot of assumptions here, but let's just assume that the consent is good for you as the seller. And it obtains the consent you need for the type of outreach you're making, right? Both the kind of system or equipment you're using and the scope of the outreach, right? Then you're going to have that same unlimited consent rule applying. If you're doing it in a situation where you don't have a prior express written consent, right? And you're going to do a marketing call. Maybe you're doing a live marketing call with a desk phone. Let's just make it very simple. And you want to rely on that lead to do it. If you don't have prior express written consent, then you are going to be in like DNC rule land. And you're going to be asking questions like, do I need to scrub the DNC, National DNC registry? And can I make that outreach? Under the TCPA, there is an exception for established business relationship. And that exception has, a 3-month and an 18-month prong to each of the issues. One of them is a 3-month prong for an inquiry. So 3 months from the date of inquiry. The other is 18 months from the date of the last purchase. So you're going to ask yourself, do I have an established business relationship? based upon one of those things. The issue with the lead context, and I just want to flag this, is that the regulations are written as if that information or established business relationship is between the seller and the consumer. And so when you inject a third party into that process, there's at least a floating question as to whether that could create an established business relationship. Historically, there was not a lot of litigation on DNC regulations. It kind of was a tack on in certain situations, but everything was happening in the auto dialer space. That is no longer the case. We have had a major shift into, we are living in the DNC world, both internal DNC claims and national DNC registry claims. So I expect we'll start to see questions like that answered by courts, but right now, not a huge, weight of authority behind those kinds of questions, just a flag.
Yeah, absolutely. Another question translating this next one. We were talking about automated, but what about one-to-one text from a salesperson to a customer? So I'm going to assume they're talking about, I've got a lead and I'm going to use my phone to text message them. How do the rules play in effect here?
If they're texting on their cell phone using the native messaging app, I'd say that's probably not an ATDS. I think the FCC has even made that clear at this point. I got a laugh on that one. But if it is through a system, like a platform, for example, cloud-based, or it's, tied to your CRM or something as an add-on, you are going to have still the ATDS question. The question is whether or not your system that you're using to send that one-to-one text could constitute an ATDS.
Okay, another question is about initiating contact with the customer via an initial SMS and then requesting their consent. How does that play out?
This is an oldie but goodie, and it actually kind of goes back to the can you cold call someone and then ask for their consent? We saw a lot of that kind of questions, in the 2014, 2015 timeframe, and now with text messages being what it is, it's a good question. But the short answer is you can't do that. You have to actually have the consent to make the outreach in the first place. So if you think you need the consent, then you need to obtain it first. You can't text someone and then ask them for it. There is kind of a variation on this, which is you can create situations where there is like a call to action and someone texts in to get more information about something, like they want to sign up for your text marketing program. Your creative says, hey, sign up for my program, text me here, right? You text them, send them the link to the web form where they can actually do that thing. That would be okay, but that's a different scenario.
Yeah, that's what the next question was trying to allude to, that process of including a message to link to longer terms for a consent piece. Another good question, what's the difference between express consent and express written consent?
So again, going back to the automated calling provisions of the TCPA, express consent or prior express consent is really a basic form of consent. It is for informational calls and texts, and it is the consumer providing a phone number for purposes of communications at that phone number for some specific purpose. And that is going to be, framed by the scope of the relationship or transaction in which the phone number is being provided. Or if you want, you can frame it with contractual terms, right? Like, you have an account agreement and it says you can make certain communications with this person. The prior express written consent is a term of art. It is a list of 7 or so requirements that the FCC says you have to have in order to make marketing outreach using an ATDS or an artificial voice or pre-recorded message. Again, the requirements are you have to identify the seller, you have to identify the phone number, you have to get an affirmative agreement from the customer. You need a clear and conspicuous disclosure that you can contact this person with, for advertising or telemarketing purposes, something like that offers something that indicates an advertising or telemarketing purpose, that you can use an automated system to do that outreach, and that this person is not required to consent as a condition of any purchase or sale or of goods or services. And that consent has to have a signed written agreement. So all those requirements have to be fulfilled to have prior express written consent. It is a much higher threshold.
Okay, another good question. Should lead providers, including those who buy from affiliates, so buyers, should they get consent before they buy the lead?
That is a great question. And that is something that the lead gen industry they're just grappling with that right now, right? I mean, the question is that what you want to be doing? Do you want to be engaged in that process? Because essentially what used to be seen as kind of status quo was, you can just get this generalized consent, maybe with like a link and a list of partners, right? And the FCC says now you cannot do that. Starting in January of 2025, that is not valid prior express written consent. So you're going to need a plan that is going to help you address that. I think the answer to that is only the business can know what is going to work for them and where they want to go with this. And I think the industry too is going to have conversations on this. But that is the question. And it's a little bit less of a legal question. But the legal questions that flow are, if you are going to try and do it, you're going to have to address, obligations for who's ensuring that consent is good for the purpose that it's being collected, whether or not your contracts are going to be allocating responsibility for that and how you're going to do that. The consent record collection issue, that one's a biggie. So all those things are going to need to be addressed for anyone who's engaged in the business of collecting consent for someone else.
Yeah, and from a compliance and privacy officer position, I mean, I want to encourage that you want to have, you need transparency. You need to see the consent that was provided. You want to have some visibility in what was being performed there. So I would highly encourage the industry to move in that direction of capturing make sure they have the consent before they call or contact. But yes, we'll continue to debate that. One more question I have, and then we can open up for a recap, or maybe there's one more good question here. I haven't seen this one. Do you need express consent for ringless voicemail? That's a technical specific question, but how about that one?
No, it's a very good question. So ringless voicemails are pre-recorded or artificial voice calls according to both the courts and the FCC. So you are not going to be exempt from the automated calling provisions using ringless voicemail. You need to comply. So if your ringless voicemail is informational, then you need to get that prior express consent. And if it's marketing, you need that prior express written consent.
Okay. Were there any other questions in the section that you thought would be good to address before we move to wrap up?
Hey, Ben, how about this one? How do you capture and store consent?
That's a great question, Margaret. I would highly encourage.
What would you use to do that, Ben?
Trusted form from ActiveProspect, for sure.
That was a legit question.
It was.
I think we're all just taking a quick look through the questions.
Yeah, there's a lot of good ones in here. Okay, someone asked this question: is the one-to-one consent requirement going to be required for non-auto dial calls? There is a prominent attorney in this space who initially flagged that there is a distinction in the FCC order between automated calling, which is what they're regulating with the prior express written consent one-to-one requirements, and the DNC requirements. That distinction exists, but I will caution everybody that I have already seen the plaintiff's bar getting creative on that one and trying to apply prior express written consent requirements to the prior express invitation or permission exception to DNC. So because there's a signed written agreement requirement, that is what they're using as a hook. And I don't believe that is an accurate read or an appropriate read of the regulations, but it is something they're trying. And if you want to feel good in defending a claim like that, you can just have prior express written consent anyway, and you won't have to worry about it. So that is something to think about. I will be duking that out in court in the coming months, and you probably will see an order at some point on that issue. But, I can tell you that you will have much more comfort if you have prior express written consent.
Yeah, much agreed. Let's go through a recap. We talked about a lot of things today, but of course, as we try to conclude, try to bring it all home, what's some quick takeaways that you will offer clients you serve in this space, Alexandra?
Well, the first is that SMS is a great way to communicate with your customers. Super popular, lots of people doing it. You want to join the bandwagon? That's totally fine. Just remember that when you do, you're buying risk. So you're going to want to be doing what you need to do to reduce that risk to the extent you can. TCPA is not a joke. Everyone on this call, I think, knows that, or else they wouldn't be here. But you really do need to make sure that you're obtaining the consent you need to make that outreach. And if you're in doubt on what level of consent, there is no harm in going conservative, right? Especially if you're going to the trouble of collecting consent to begin with. It's a small change to collect the consent versus what you'll have to do, the kind of gymnastics you're going to have to do in arguing that you weren't required to get it. And that kind of goes to the last point, which is don't assume that just because you're sending text messages, you're not using an ATDS. We talked about a case or a situation today with one-to-one where you might have a question. So it's very easy for people to say things like, we're not using an auto dialer because they're not using a predictive dialer, or we're not using ATDS because we don't randomly or sequentially generate phone numbers. But that's not necessarily what courts are looking at when they're making that determination. Takeaway number 2. If you're getting that consent, which again, you should, you have to make sure it's right. So if you think you're getting informational consent, make sure that the communications you're sending fit within that bucket. And if you are making marketing outreach, again, get that heightened prior express written consent. It is a laundry list of things that you have to have. But if you obtain it, that is good as gold. FCC, which I know is one of the reasons why we're here today. My favorite folks these days, they not in a good way. But I think what they have done is solidify some things that a lot of us have been advising for a long time. So I do think, to the point of clarity, that has been at least helpful. And so where the FCC says we should do something and tells us how to do it, for example, how to get consent for every single seller, follow that because that is a roadmap, right? So when we are talking about the FCC order in January that just happened and how the effective date is coming up next year, the things that you can be doing to get ready for that change, reviewing your disclosures to determine what kind of disclosures you need to be giving, whether or not the disclosures are good for the purpose you're collecting them for. If you're a lead gen, that's going to be a more complex question for you than if you are a brand. But if you're a brand, consider issues like, I have multiple brands under my umbrella, and we have text programs as to each of them. How are we going to deal with consent for those programs? Record keeping. FCC order says you got to get consent records. Obtain them. Don't leave that to somebody else. That is now definitively your job as the seller. Contract review. Visit your contracts. Make sure they're in compliance and set you up for success on the FCC order. And revocation. Pay attention to what the FCC is doing because we're going to have more rules soon.
Yeah, excellent. Alexandra, thank you so much for joining us today. We'll make sure we include a link to your firm, Manatt's TCPA resource pages. You can subscribe for more information and updates from them as this is happening. We'll also we have your contact information is there for those who are needing some great legal counsel in this space. Encourage everyone to consult legal counsel, internal, external, work closely with your marketing peers, the whole process, so they can help you source out the risk. Make sure you follow us on LinkedIn for regular updates, posts, and more at ActiveProspect.com. Episode 4, it's called Don't Panic, Prepare, Navigating the Undefined World of Robocalls and Robotext. with Tammy Glover Fowler from Convoso, Compliance Officer, and Pooja Amin from the Troutman Amin firm. Thank you, Alexandra, very much. And Margaret, you have a speaking engagement coming up. I believe you're going to be at the Home Services Growth Summit in Atlanta at the end of the month as well. Yes? That's
correct. And I'm going to be moderating a panel there where we're going to be diving more into the FCC changes across a lot of not just FCC compliance, but also data privacy compliance as well. So we're going to be covering a lot of related content here as well.
Excellent. Thank you both very much. Really enjoyed the conversation. So thank you.
Thank you.